Hi everyone, I thought I would have a go at using a cool new feature called Screencast-O-Matic to see how we go with recording our little lectures each week. So what I'm doing in terms of the flipping the lecture stuff, I talked about this in week 1, is that there's just some parts where I'm just kind of standing and talking to you. So that's what I'm going to be recording. Okay, so you don't have to just watch me stand and talk, or you don't have to listen to me stand and talk online. You can literally just do this anytime in your own time. So fingers crossed this works and we get some pretty good, interesting discussions happening in class then, instead of listening to me stand and talk. All right, so this week we're talking about legislating and policing youth deviance. The part that I'm focusing on in this little video is the legislation part. So I'm literally going to just talk through a few of the issues around legislation. We'll touch on this a little bit in the face-to-face lecture, but it's just to give you some background. Before I start though, I do want to talk very briefly about what I call a few basic premises, and I usually have these in each of my lectures. The first one for this week is that we need to remember that juvenile justice is a system that's constantly in flux. It's constantly being renegotiated and reshaped. As Munsey and Hughes described it, it's a confusing and messy business, and that's very close to the way that I would think about it. Even when the Newman government came in, there was a whole bunch of stuff that was changed because they reviewed everything, and that continues to happen with each new government that comes in. It's very much informed by shifting understandings of youth crime and violence. So the way that we think about youth crime 1 month before a new government comes in could be different to how it's thought about after the new government comes in. It's also influenced by juvenile justice models, particularly welfare and justice that I talked about last week in that lecture. And of course, the overall guiding principle of youth justice in Queensland is diversion, but I'll talk about that more later, specifically in the online Collaborate session that we have. For instance, the idea of diversion is that we need to take young people out of the system so they're not labelled and all of that sort of thing. Harsher forms of outcomes such as detention should be used only as the last resort, but that's one of the changes that the government brought in. They took away that, and now they can be detained at any time. So there's a whole bunch of key players in youth justice in Australia. Police are obviously a major one, and I'm dedicating the whole second part of this lecture to that. There's juvenile justice departments. So the Department of Corrections, for instance, is related to adults. So it's the Department of Communities, which is looking after young people in Queensland. There's also statutory bodies, commissions, ombudsman's offices, human rights and equal opportunities commissions, that sort of stuff. Anti-discrimination, that type of thing too. There's other state bodies, there's DJAG, there's legal aid commissions, law reform commissions, crime prevention units, bureaus of crime statistics, victims tribunals, and of course there's advisory bodies in various different areas of youth justice. There's also the Commonwealth Government, which focuses on employment training, higher education, income support, as well as the ratification of international human rights instruments, conventions and treaties. And then we've got non-government organisation and local government. So in terms of local government, there are sometimes punitive approaches to young people, and I'm going to talk about those a little bit more in the second part of the lecture that we do online. And non-government organisations typically bear the brunt of supporting young people whose order or whatever is not going so well in terms of being supervised in the community or being part of detention. But as well as that, they provide a lot of community legal support. There's youth affairs councils, religious groups, and international non-government organisations that are all involved in that. So things like the Australian Youth Affairs Coalition, which is the Australian peak body at the national level, and then there's local stuff. So in Queensland, for instance, there's Open Doors, which is for LGBTI young people, Brisbane Youth Service, which is for all young people, and Youth Advocacy Centre, which helps young people who have had contact with the system or are having contact with the system. So in Queensland, Both welfare and justice-oriented supervision takes place through the Department of Communities. Oftentimes there is overlap, as we discussed last week. Most young people who are engaged in crime, you'll find in the past, has been a victim of crime also. The different types of tasks that the administrative process involves is stuff like court reports, specialist counselling, establishing and administering detention centres, supervising young people in those detention centres or in the community, or doing community work and that sort of stuff. Of course, collecting and disseminating information about juvenile justice and developing different forms of policy in different areas. So all of those things happen in the administering side of youth justice in Queensland. If you're interested in that type of work, then it's Department of Communities that you really want to focus on as your target endpoint when you're doing your degree. Here's just a little bit of a diagram of juvenile justice processes in Australia. It gives you a sense of where young people can come out of the system. So they're processed by the police for an offence. They can get like a police caution, warning or conference, or if it goes to court, they can go to detention, pre-court custody, which is remand, or they can be unsupervised. If they go to court, they can be transferred to a different court, or they can go to program attendance or something like that in terms of illicit drug diversion. If the charge is proven, we can see there's unsupervised orders, community-based orders, detention orders, and there's parole or supervised release depending on that type of circumstance. Again, we can see different outcomes here from court: being remanded in custody, supervised in the community, or unsupervised bail. It just gives you a sense of how the process works. It's different in every state, and that's something to think about. What legislation are young people subject to? There's specific juvenile justice legislation, general criminal law, of course, legislation around criminal procedure, legislation around bail, general sentencing laws, and international human rights conventions and instruments. One of the things that we also need to be wary of is that young people can become caught up in the net of other types of legislation. So there's an example here down the bottom where a young person, if we look at the definition of a young person with youth services, this particular young person was jailed for consorting. He was associated with people who were engaged in criminal activities, and he was charged under the bikie laws. And that young person had a significant intellectual disability and certainly couldn't be considered a 21-year-old by any means. So there's a link to that story if you want to have more of a read. So I'm going to talk through the legislation, and this is my very dodgy non-lawyer understanding of what the legislation is, so that you get a sense. As I said before, the Criminal Code, the Summary Offences Act is probably another major one. The Police Powers and Responsibilities Act is again another major one, and the Youth Justice Act. I'm going to talk through each of these in a little more detail. There's also the Charter of Juvenile Justice Principles, Child Protection, Child Services, Juvenile Justice Regulation, again, which is specifically Queensland, the Youth Offenders Interstate Transfer, and we've got things like the Children's Court Act. So all of these are related in some way to what happens with young people. The Charter of Juvenile Justice Principles is probably the main one that specifically influences juvenile justice in this list. The most common powers that influence the lives of young people in terms of the PPRA, the Police Powers and Responsibilities Act, is definitely whether or not a police officer reasonably suspects that a person may have committed an offence or is at risk of committing an offence. Now, this notion of reasonable suspicion is a very interesting one, because it is really up to the discretion of the officer in terms of how they actually define that. They can search the person and anything in that person's possession without a warrant, request a name, age, other details, enter a place and stay for a reasonable time, stop and detain a person, order a person to move on under the basis of that PPRA legislation. That is by far one of the things that influences young people's lives the most, and I'll talk about that more in the online Collaborate. It's also about causing anxiety of a person entering or leaving a place, interfering with trade or business, disorderly, indecent, offensive conduct, disrupting the peaceable, orderly conduct. So this could be, for instance, in the study that I did, which I'm going to talk about more in the lecture, this could be a young person that's sitting with a whole bunch of other young people who are dressed in black and they identify as goths or emos or whatever, and they're sitting near an ATM. So a shop owner or somebody else makes a complaint about those young people. The police can then come down and act on the basis of this legislation. Summary offences, particularly public nuisance and unlawful gathering in a building or structure, can often be specifically targeted towards young people. Behaving in a disorderly way or an offensive way could just simply be offensive language, obviously, but it can also be loud conduct, being boisterous, that type of thing. As well as that, unlawfully gathering is something that specifically often targets young people because they hang out in groups with other young people. It's very unspecific, and that, again, it's up to the discretion of the officers in terms of how they actually define that. There's a whole bunch of other things there as well that young people can get into trouble with in terms of this particular act. The Youth Justice Act, there is so much to say about this, but I'm not going to dwell on it. It's about 330 pages long, but there are a few issues. It's a very young age to be considered an adult. I talked about that a little bit last week and in the first lecture too. There is a massive tension between justice and welfare perspectives. The young person is being at risk, is very vulnerable, but also being an offender and is considered dangerous and things like that, and a threat to the community. It states diversity needs to be considered, particularly indigeneity, but it's very obvious that Indigenous young people comprise more than half of all young people under juvenile supervision, and about 75% of those in remand and in detention and things like that. It's very obviously contradictory in terms of how the Act also describes youth justice. The community needs to be protected, but also the young person needs to, the focus on the young person is to consider the developmental stage of that young person, but they still nonetheless need to take responsibility for their actions. I could go on, but I won't. There's a lot of recent changes. I'm actually going to talk about this in the lecture that we do online. A lot of this, though, is currently up for discussion because it's being reviewed again by the new government. There's local legislation which can impact on young people, City of Brisbane Act, Local Government Act, the youth strategies, that sort of thing. When I looked up the youth strategy recently, this is the image that they used here down the bottom, the image that we've got here of the girl. Apparently that is representative of all young people in Brisbane. And of course we know that that's definitely not true. It doesn't represent any of the diversity that we have in Brisbane. Human rights instruments like the UN Rights of the Child, the UN Standards and Minimum Rules for Justice. I'm going to go through those a little bit in the lecture as well, and there is more detail about this in the textbook reading for this particular week. There are minimum standards, but some really important examples are that, you know, the emphasis should be on the well-being of the young person. Any reaction should be in proportion to the circumstances of the offender and the offence. But that doesn't often happen. You know, we have young people being incarcerated for stealing pens or stealing Freddo frogs or whatever. There's young people's right to privacy, so that we avoid the harm being caused to her by undue publicity or the process of labelling. And of course, again, that can be a really problematic thing. Naming and shaming in courts is very common in Queensland. Again, the background and circumstances need to be taken into consideration. We'll talk about this a little bit more in the lecture that we have. Thanks very much for listening, and I'll chat to you soon. See ya.